Yes.
Please also, item number, I like to mention also item number 37 of today's list. In this matter, CD has not received my lord. Let this matter be listed after we. Number 37.
37 CD
Yes.
not received list
Yeah.
again on
There is entry order that may be extended.
interim order passed earlier to continue. Next.
But as regards item number 27, I'm appearing on behalf of respondent numbers 2 and 3.
27.
I'm
37. This item.
37. There is an entry order that may be extended, man.
Yes, we have already done it. Interim extent.
30, even 8. All right.
As item number 27, I'm appearing on behalf of respondent numbers 2 and 3. I have filed the respective affidavits and that may be called for. Obligement.
May I please, my lord? My lord, I beg to mention item number 17, my lord.
17.
17, my lord.
Yes.
My lord, there is already an order in this case, my lord, order dated 22/9/25 to list this before any other bench, my lord.
Yes. List the matter before the appropriate bench without me. Discussion.
Obligation.
Lordship, I beg to mention item number 3. I have instruction to withdraw the matter
You are
petitioner
Mr.
B. Fukon.
On the prayer of Mr. B. Fukon, learned counsel for the petitioner. Matter is dismissed as withdrawn.
May I please, Lordship? I beg to mention item number 28. We have filed Wakalatnama yesterday. Matter may be come after a week. I am for respondent number 2.
Lordship, I am for the petitioner, Lordship. Already petitioner received, Lordship.
You are objecting.
Take up this matter today, Lordship. Already
They have-
141 days behind the bar, Lordship. Already 141 days behind the bar.
141.
Oh, yes, Lordship.
So charge-sheeted matter.
Yes.
Okay, well, let's have it on Monday then.
Monday of less.
37.
May I please, Your Lordship. Lordship, in respect to item number 34, my lord, perhaps CD is not there, my lord.
34. CD not available. List again on
It's an interim order, my lord.
interim order passed earlier to continue.
Obliged, my lord.
Even make on.
May I please, Your Lordship. Lordship, I beg to mention item number 38, Lordship. Lordship, perhaps CD is not available, Lordship. 38.
CD not received. Same order. Yes.
May I please, your lordship, I beg to mention daily list item number 40, lordship. CD has not been received. 40. 40.
40.
40.
Same order.
Interim is dear lordship.
Interim order passed earlier to continue. Yes.
Much obliged.
Which one? 38. Think so, interim to continue 38.
Please, Your Lordship, I beg to mention item number 47 for an adjournment, Lordship, on the ground of bereavement in the family of the conducting councillor.
Okay, 47.
Interim order may be extended, Lordship.
Interim order passed earlier to continue. List again on valid date.
Yes, I beg to mention item number 43, my lord.
Yes.
There was some other day, my lord.
Prayer of learned counsel for the respondent. List again on. Yes.
May I please, Your Lordship. Item number 11, Lordship. The conducting senior counsel is out of station. Could it be taken up on 28?
Right, item number 11 on
11.
28.
Yes. Delivery.
May I please, Your Lordship? I beg to mention item number 19. My senior is out of station, Your Lordship.
19.
19, Your Lordship. Kindly matter may be taken after 3 weeks, Your Lordship.
After?
3 weeks.
All right. 3 weeks.
God bless Your Lordship.
May I please, Lordship? Also, I beg to mention item number 33, my lord. Up to the CD was called for, probably not received. 3. Up to date CD was called for. Not available.
All right. Same order, up to date CD will do. No,
Interim order is there.
very order first.
I'm obliged.
On lordship, 14th of May, Lord.
I'm obliged. Number 1.
Everyone. There's a pending case, my lord, succeeded where the case is already victim has been examined under section 60. And from our evidence, it appears that she was a consenting party. And age is around 16 to 17 years, my lord.
Trial is on.
Trial is on. So at this stage, notice may be issued, my lord.
Run it comes. Issue notice to respondent number 2. So call for the scanned copy of the TCR list again on.
With me. Item number 2.
May I please, your lordship, this is a charge sheeted matter,
Commercial,
commercial.
Okay.
TCR may be called for.
scan copy of TCR.
13 May.
13 May. Highly obliged.
Item number 4.
My lord, your lordship may call for the scan copy of the trial court.
Scan copy, yes.
Obliged.
13 B. Item number 5.
Right, please, Your Lordship. It's a regular bail application, my lord. Here, my lord. There is apparent violation of, my lord, that 22(2), my lord, of the constitution, because violation of 22(2), my lord, because 24 hours they were not produced, my lord. Lordship, kindly have a look at the FIR, my lord, page 17, my lord. Very longish FIR, but if your lordships. So kindly see that the information was received on 3/4/2026 at 11:30 PM. So it's in, my lord. 3/4. Thereafter, my lord, these 4 accused persons were, my lord, apprehended, and the driver, my lord, he managed to escape, my lord. And the IMFL liquor was, my lord, seized, my lord. Therefore, lordship, kindly see on 4/4/2026, lordship, seen, my lord, at 1:36 AM. 4/4, my lord. That means the intervening night, my lord, after receiving information, thereafter, my lord, around. Now then again, last, my lord, at 3:55 AM, the duty party along with 4 apprehended individuals seized so and so were returned to PS. So this is the time, my lord, when they were in effective custody, my lord. And now, let me kindly have a look at the.
On 4/4/26 at 1:36
Yes, my lord.
AM.
AM.
Total.
And they were.
So according to you, this 1:36 AM is the effective.
Yes, ma'am. There is a scissor list also. We have annexed, my lord, and page 20, Lord, you kindly see the forwarding report. They were forwarded only on 5/4, my lord. That means not on that day, my lord, next day, my lord.
That means 4/4/26 after midnight.
Yes, yes. And it will be apparent, more apparent from the seizure list. Lord, you kindly see. And the arrest.
Where is the forwarding?
Forwarding, my lord, that is page 20, my lord.
Yes.
Now, my lord, kindly see, we have annexed the order of the learned court, my lord. 23, that also shows they were forwarded on 5/4. Now kindly have a look at page 25, my lord. That is the, my lord, seizure list, my lord. There also lord should find page 25, that is the type copy. Page 25, 4/4/2026, 1:36 AM, my lord. And all these 4 persons. Now, my lord, kindly have a look at the arrest memo, my lord, page 29, my lord. This is of the accused number 1, my lord, page 29. There column 5, lord should find, my lord. Date and time of arrest, 5/4/2026, 8:45 AM. So they were in effective custody, my lord, from 1:36 AM of 4/4. Thereafter, they have been served with this, my lord, arrest memo on 8:45 AM on 5/4/2026, my lord. And they were produced before the learned courts below in the afternoon. This is one, my lord. For the others also, we have annexed 4 arrest. Four arrest memo, same, my lord. Page 32 is of the other one, my lord. Tahaz Ali, page 32. Same, my lord.
All were found together, so same
Yes, yes.
timing will be same for.
Yes, yes, that's, I'm showing the arrest memo, all times are same, my lord. We have annexed all, my lord. So here, my lord, apparent violation of the 22 and my lord as well, that 58 of the BNSS. And in fact, these are 7 years offenses, my lord. So, my lord, that is, there is another violation also, my lord. The 35(3) notice, my lord, now lordship knows, my lord, it is mandatory to be given, my lord. As a matter of rule, my lord.
This is lordship CD may be called, I will give a short date lordship.
How can
I
it
will-
be, he'll be
I
in
will-
case of illegal detention, my lord? What
I
is-
will lordship may fix short date lordship.
What is there to see in the CD?
Not in each and every case, my lord, they submit in a general manner, my lord, because here apparent violation, you
But
submit on
because-
that count.
On a date of arrest and time of arrest is 5/4/2026 at 8:45 lordship.
In fact, cost should be
And
imposed, my lord.
for the- And-
We are on effective date of arrest. That is the law, you know that. And by your own statement, seizure was made at 4/4/26 at 1:36 AM. So are we to assume that even after seizure, they were allowed to roam around?
But in this type of cases, lordship, formalities are there, lordship, so.
Formalities are not above the constitution. There is a constitution mandate 22(2), you just read it once. And 58 of the BNSS.
I think the constitution framers were also aware of the formalities. It will pass orders.
Fine. Much obliged. Whole judgment not necessary, my lord, Subhas lordship's order is also there on that judgment not necessary. Much obliged.
May I please, your lordship. Lordship, regular bill application lordship and the NDPS commercial lordship. CD may be corporate is from Gauhati GRPS. But apparently I have gone through the entire record lordship, but the conscious possession is concerned lordship is not their lordship. Well, CD may be at this stage lordship, CD may be called for.
CD.
It's from Gauhati lordship, GRPS.
15/5.
Oh, obliged lordship. Number 7.
Lordship, this FIR was filed on 18/2/2026 and 21/2/26, Lordship, I am arrested. And the case was registered under section 64, 74, 77, 79 BNS, Lordship. FIR is case number 13, Lordship. I am Zuman Das.
What do you expect today? Yes, CD.
Item
Okay.
number 8.
Lordship, kindly pass over the matter for the timely closure. Learned Senior Counsel is engaged in court number 1, Lordship.
All right.
See, this is for the first time it has come on motion. So in any case, we need some time to give a parawise reply.
Let him come.
Item number 9.
Wait, please hold on. Here, my lord, the scan copy may kindly be called for. It's a charge sheeted case, my lord.
Do you file our objection also?
They file.
Next day.
On the same subject matter, she was earlier arrested, my lord. They have released on bail. After this case, my lord, second case, my lord.
You're appearing for whom? Oh.
CM Vigilance Forces.
Oh. When do we want?
That are date.
If in the month of May, my lord, maybe 18 May.
What was this case?
Huh? Execution of the sale deed and give deed, my lord.
Overlapping of cases, my same subject matter. She was earlier arrested. She was allowed to go on bail. By the learned special judge, my lord. Thereafter this case, here they have added another allegation regarding that it was mutated now.
Okay, on the prayer of learned special public prosecutor seeking time to file objection. Place the matter again on.
My lord, possibly that along with the TCR, my lord.
Place the
TCR,
matter
my
along
lord.
with.
The TCR trial could record.
Oh.
my lord.
Also call for the TCR. TCR has not been called for.
First time.
Also call for the scan copy of the TCR.
Much obliged, my lord.
Item number 10.
May I please, Lordship? The 482 application, Lordship. The petitioner is the register owner of 10. Petitioner is the register owner of vehicle, Lordship. His vehicle was seized in connection with this case. Lordship. Kindly see the page. Number is 9, Lordship. While preparing 22 number of cattle, Lordship, and the vehicle is a livestock vehicle, Lordship. One Aminul Mial who had the vehicle of the petitioner, Lordship, and carrying the set 22 number of cattle, Lordship. I have annexed the cattle purchase receipt also, Lordship, that is page 20, Lordship. And page 18 and 19 is the registration certificate, and 19 is the certificate for is the vehicle is a livestock body, Lordship. This is vehicle is recorded for the transport of cattle and buffalo, Lordship. Cattle was not stolen cattle. I have annexed the cattle purchase receipt also. The present picture is the register owner of the he filed a Zimma petition for Zimma of the vehicle, Lordship. And as his apprehension that he may be arrested when he appear before trial. Kindly allow him to appear before trial for and what is the RC as well as the cattle purchase receipt, Lordship. While loading the vehicle, he was not present, Lordship. He is পুরো বাচ্চাটা গাড়ি লই গেছিল
and 14 of child and adolescent labor is also. Section 3A slash 14 of child and adolescent labor and prohibition.
driver one of the his driver, Lordship, he is one of the neighbor, Lordship. He was went to the Gauhati, Lordship. He was travel the said vehicle, Lordship. And when the vehicle was intercepted,
There is no allegation against the owner.
owner, the driver, Lordship, the election against the driver.
Heard learned counsel for the petition and heard learned additional PP. This is an application under so and so. as per the FIR, the vehicle of which the petitioner is the owner was intercepted in front of Hajo PS, and 21 numbers of cattle suspected to be stolen were recovered from inside the vehicle. And the driver failed to produce any valid document. Full stop. Call for the CD. Having regard to the fact that there is no such allegation against the present petitioner in the FIR, it is provided that in the event of his arrest, the petitioner shall be released on interim pre-arrest bail of rupees 50,000 with a surety for like amount to the satisfaction of the arresting authority. It is further, in connection with the aforesaid case, it is further provided that the petitioner shall appear before the IO within a period of 10 days from today with all necessary documents and cooperate with the investigation. List again on
18.5.
Much obliged.
Standing at image.
Well, I'm showing my lord. I'm showing my lord.
That, my lord, I am already in 43 days in jail, my lord. My lord, only, my lord, there's the allegation that, my lord, I have taken, my lord. Although there is no demand, my lord, they have recovered, says that they have recovered 10,000 rupees from my possession, my lord. And already everything is seized, my lord. I am not on merit, my lord. Only, my lord, in 43 days, my lord.
This is a matter of trap, and money has been seized red-handed. So I need a shortest time to give a parawise reply, and the CD may be called for. Some sort that may kindly be given to deal with.
where is the FIR?
FIR page, my lord, 13, my lord. Your lordship will pay 15, my lord.
This is with regard to the bank manager and
He is the bank manager, my lord. Allegation is that, my lord, he's for filing, approving the application, my lord, he's asking for money. But nowhere stated there, my lord, how he demanded, my lord.
That is the question of trial here, lordship.
File it, wait a minute. File pe aana na. মোৰ ফাইলটো নাই নাই তো ইয়াৰ জুনিয়ৰ ঠিক আছে আছে ক'ৰবাত জুনিয়ৰ আৰু এটা আছে লিখি থৈ
The problem with giving you time to file objection is that by that time statutory period will be over.
Short date may kindly be, otherwise
Next Wednesday.
very short date may kindly be given.
That is the very short date. Next Wednesday.
Next,
my lord. Tuesday.
next Tuesday. Next
Tuesday.
Tuesday. Next
Okay, you
Tuesday.
want even shorter. Okay, fine.
Fifth.
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 What fifth?
Fifth
No,
or
not
fourth.
50 is not next Tuesday. Next
Ah.
Tuesday is 28.
Oh, sir. 28 today, today is
By
Friday.
it will
We
be how
have
many
to give
days?
it.
Today is
that-
43 days and that day, my lord, near about 50 days, my lord.
At least 7 days, 60
Today
days.
is 24th.
Today is 20.
60
Today is
days,
24 and
30,
today is 43 days.
And let it be on Monday, your lordship, next Monday, on 4th. Positively, we'll give parawise reply and the CD we will produce.
Hold. Court.
Court, my lord. Court, it will be one house, one house. All right, my lord.
হাত দিনে হবো 50 days এ হবো today 43
All right, my lord. Court, my lord,
50 days.
positively, my lord. on that. Because
To that I vouch
Them
for.
also learned in your counsel for the petitioner. Learned counsel representing CBI prays for a short date to file objection. Hence list the matter again on 4th of May.
Much obliged.
Item number 12.
May I please tell us? POXO is there, so at this stage notice may be issued. That's number 2. POXO is there, Lordship. So notice may be issued. That's
Notice to respondent number 2. CD.
Date two.
13B. Item number 13.
my pleasure, lordship. Lordship, this is POXO matter, lordship. POXO 8 is there, lordship. Notice to be, lordship.
Same order.
Lordship, a short date may be given, lordship.
No, you should notice what is the point of short date.
But we will send it to speed post, lordship.
Mhm.
Speed post will be sent, lordship, that may be. And POXO 8 is there, lordship.
Short. Speed post notice.
Five.
Post area block sub notice speed post area divide to register area as a circular area. Notifications.
8, lordship. 8.
8.
Obliged, lordship. Deeply obliged.
14.
May it please the lordship. Well, by this criminal writ petition, we are seeking quashing of an order by which proclamation proceeding was initiated against me, and also the consequential order of proclamation by a court at Panipat, Haryana. Now, this impugn order, my lord, arises from a proceeding under 138. Initially, I entered appearance and I was admitted to bail. Then time to time, my lord, I was on representation. Admittedly, my lord, there was some default on my part to appear, 1 or 2 occasions. Initially, a non-bailable warrant was issued. Then eventually, my lord, page 41 order was issued. Page 41. By which trial court invoked section 42 of the BNSS, 84 BNSS.
Page
Page
41.
41, page 40. May I read the order?
Mhm.
Non-bailable warrant issued to accused not received back. Therefore, I am satisfied the accused is intentionally avoiding the service of warrant and presence of accused person cannot be secured through ordinary process. Hence, proclamation under section so and so against the accused be issued for 21/2/2026. Then this statutory conditions. Now, kindly take up for a moment BNSS, section 84.
Now, before that, what about jurisdiction
Yes.
of this court?
Firstly, I'm come to the jurisdiction. Can you take up the constitution first? Section 226, article 226(2).
Yes, read.
I'm reading article 226(2). The power conferred by clause 1 to issue direction, order or writs to the government, authority or person may also be exercised by any high court exercising jurisdiction in relation to the territories within which the cause of action wholly or in part arises
for the exercise of such power, notwithstanding that the seat of such government or authority or the residence of such person is not within those territories. It says High Court can exercise its writ jurisdiction if the cause of action arises wholly or partly within the territorial jurisdiction of that High Court, notwithstanding the fact that such authority is outside the jurisdiction of this court. That is 226(2). It's a subtle proposition, my lord. This High Court can exercise provided some part of cause of action arises within the territorial jurisdiction of this court. There is no res integra. Now, in 138 proceeding, now it is judicially settled. There are 5 constituents to an offense under 138. Drawal of the check, presentation of the check, dishonor, statutory notice, and non-payment. These are the 5. Admittedly, the check was drawn at Gauhati. It was returned by a bank at Gauhati. So, admittedly, the cause of action or some part of cause of action arises within the jurisdiction of this court.
Were against the issuance of NBWA, is it not?
Now, I will come to that.
Proclamation.
I will come to that. I'm basically on maintainability, I'm not. Because this is the second round of litigation. Earlier, I also filed a criminal writ petition. Their notice was issued and pending final adjudication, assailing the very initiation of the complaint proceedings. That is pending here. Let me show the order. It will be on. This is the second round of litigation. This is the earlier criminal petition filed by the same party out of the same proceedings. Here notice was issued and pending adjudication. Here maintainability is admitted. I referred certain Supreme Court judgment and that was quoted there. Now, may I address on the merit of this impugn order, page 41 and 47? I will
Yes.
show I will prima facie it is bad. Can you take up this BNSS? Just for a moment. 84. (84)(1). If any court has reason to believe whether after taking evidence or not, that any person against whom a warrant has been issued by it has absconded or is concealing himself so that the warrant cannot be executed, such court may publish a written proclamation requiring him to appear at a specified place and a specified time, not less than 30 days from the date of publishing such proclamation. May I just pause here for a moment. One says, if the court has reason to believe that the person against whom this NBW issued has concealing himself or absconded just to frustrate this execution of this warrant, then a written proclamation. But it comes with a rider. It must fix a date and a time which is not less than 30 days from the date of proclamation. Now, this expression, my lord, reason to believe, has a definite legal connotation. In fact, this has been defined under BNS. Section 2, subsection 19, define reason to believe. It says, a person is says to have reason to believe a thing if he has sufficient cause to believe that thing, but not otherwise. So, reason to believe, sufficient cause to believe. And that cause must be clearly reflected in the order. Now, so there must be some materials at that point of time before the learned trial court to draw a belief that that person has absconded or he is concealing himself. And at that stage, my lord, probably the only...
That part I am satisfied that simply because non-bailable warrants have not been received by cannot be sufficient reason to believe.
That itself is bad, my lord. Then the whole process is bad.
But I am a little bit still in doubt about the jurisdiction issue because this is against the, not against the complaint as such. This is against the issuance of the proclamation.
Yes, against
that, in that respect, no cause of action has arisen here.
No. This order was passed on a proceeding.
Anyway, who will be representing?
Yes, private respondent. Maybe respondent, my lord.
No, but this is a writ petition.
Writ petition criminal arising out of order passed in Haryana, my lord. Out of a private complaint. Because this order was passed on a complaint petition.
It is a writ petition under 226.
226.
So unless state is a party, can it be maintainable?
Yes, it can be.
Let's go back to 226.
Yes. By any court, when we are praying for a certiorari. Certiorari can be issued for quashing any order passed by the court or any authority or tribunal. Yes, it is arising out of a complaint petition, private complaint petition 138. We are seeking quashing of that order.
So why not a criminal revision? If the order is bad.
Because
writ is an extraordinary remedy.
Yes.
Normal remedy is criminal
I will
revision.
come to that also. My lord is posing a question that there is alternative remedy. That is what my lord is saying. Alternative remedy, my lord, is not a rule of thumb. It's a rule of discretion. Now there are well
So you may
accepted.
refuse to exercise your discretion here.
Well, I will come to that, my lord. I will come to that. I will satisfy your lordship. There are well carved out exceptions to this rule. I will refer to those if required. One is lack of jurisdiction. When there is a violation of fundamental right. When there is violation of natural justice. These are the three carved out exceptions of this rule of alternative remedy. In my case, there is absolute lack of jurisdiction. But these are jurisdictional facts. Existence of this jurisdictional fact will only confer jurisdiction on the trial court, not otherwise.
How can you say it is lacking or lack of jurisdiction when part of the cause of action has arisen in Haryana also?
The jurisdiction is not that absolute lack of jurisdiction. It also includes exceeding jurisdiction. When, my lord, lack of jurisdiction means lots of things. It also includes exceeding jurisdiction. It also includes when it refused to exercise jurisdiction. These are all part of lack of jurisdiction. Initially, it has the jurisdiction to entertain this criminal petition, complaint petition, I admit. But to issue a proclamation order, these are the jurisdictional facts. It must be there because it's a very serious matter. Issuing a proclamation has a serious consequences. Next stage will be attachment of the property.
Authority may issue a wrong order, may still be within its jurisdiction. Here is a case where the authority has issued a wrong order, but still it
not
is
a
within
wrong
its
order.
jurisdiction.
All my trying to submit, my lord, persuade my
It
lord.
is not a wrong order.
Wrong order is, erroneous order is one thing. Lack of jurisdiction is another thing. Here, to pass this order, at least these are the jurisdictional facts. There must be a NVW issue that was there, earlier NVW issue. Then this 8421 A, B, C has to be complied with. That was not complied with. Public announcement. Then
Those are illegalities and infirmities in the order. Those are
No,
not
no,
jurisdictional issues.
It will only confer jurisdiction, my lord.
That way, every issue is a issue of jurisdiction.
No.
Now, first you satisfy us without making state a party how a petition under 226 will lie.
Can we come to 26? We are seeking a writ of certiorari. A writ of certiorari can be issued to correct an order passed by the trial court, passed by the court below, tribunal, or any other authority. That is when a certiorari can be issued. We are seeking for quashing. Quashing can be done only through certiorari, not otherwise. So we are basically praying for a writ of certiorari. It is a well-established principles when a certiorari can be issued.
Saying it's a well-established principle is not sufficient. You satisfy us how it is a well-established principle.
Okay. Then right now I don't have this judgment dealing with certiorari. I will come out with that. I will satisfy. Let it be on Monday. Let it be on Monday.
Third learned counsel at some, hold a petitioner at some length. List the matter again on Monday as the issue of jurisdiction of this court is involved in the present case, and as also the issue of maintainability as state has not been made a party in the present writ petition. List on.
Yes. Monday?
Monday, make it Tuesday, 28, Tuesday will be better.
Tuesday.
And petition item 15.
My lord, senior is in late, my lord. Kindly pass over for timing. my lord.
Yes.
Yeah. My lord, this one has been filed for my lord quashing the order, my lord, passed by the learned, my lord, judicial magistrate at Gwalpara, my lord. Whatever in this case, my lord, your lordship, kindly to turn to page 14, my lord.
Some reply was to be filed as per last order. Somebody is appearing, you are appearing for respondent number 1 and 2.
We have taken steps, my lord, as a legal one.
Hmm?
We have taken, earlier we have taken steps, my lord, as per your lordship's order.
No, perhaps earlier prayer was made to file reply or something. You have filed anything? No.
Give 1 week time.
Huh?
1 week time. Lordship.
Let them file reply, my lord. My prayer would be, my lord. My lord, complaint case number, my lord, petition to may be state, my lord, for time being, my lord. Because in the same case, my lord, we have filed a, my lord, title suit there at
All right,
least.
we'll see on the next date. They want only 1 week. So let us fix it on next Friday. On that date, we will see if they don't.
On Thursday, my lord, on Thursday then.
All right, Thursday. At learned counsel for the petitioner, learned counsel appearing for respondent number 2, 1 and 2, 6, time to file a reply. Stroke objection. Hence release the matter again on Thursday date.
Pleasure.
Item number 18.
Lordship, for some person in the difficulties mind, senior not available. I am for respondent number 2.
Yes. Yes. He wants time.
Yes, Your Honor.
He is seeking time because
Yes.
his senior is not available.
Yes, Your Honor.
Yes. I'll learn counsel for the petitioner. Adjournment is sought on behalf of the respondent due to unavailability of learned senior counsel. Hence release the matter again on. Give a date. Publish.
Hearing B, item number 20.
Yeah, please. 483 application, Lordship. Petitioner behind the bar as on that 179 days, Lordship. Was arrested on 28/10/2025. This is charge measure, Lordship. Now, SARS also frame, Lordship. And FIR is page 9, Lordship.
On the last occasion, madam, there was a query, madam, whether charges has been framed or not, madam.
Suspect,
Report received, madam, charges framed, madam. Even the amicus is also appointed, madam.
frame, Lordship. Now, next date is fixed for evidence on 19/5/2026, Lordship. And charge sheet submitted, Lordship, on 10/30/2025. Now, charge frame on 26/3, Lordship. This is a long incarceration, Lordship. The allegation against that, Lordship, that the petitioner captured some video while the victim bathing, Lordship. And the thereafter petitioner immediately deleted and he neither does share the said video lordship nor circulate to anyone or upload any social media lordship. Regarding the section 77 and 238C lordship, which is bailable lordship, and SAS also films section 77 and 238 and reduce section 14 and 15 lordship. And 15 also not applicable in this case lordship, because the petitioner immediately delete the said video lordship. He is not neither he is a lordship, and already 179 days lordship. There is a 11 substitute witness. The trial may be taken some time, it take time lordship. The present person, local person already 179 days lordship. Behind our any condition lordship. And he is also local person lordship. And till date, no prosecutor witness was examined lordship. 26 on 26/3 SARS was found. Thereafter the case was fixed on 22/4/2026, but on that PW was absent lordship. Now next date is fixed on 19/5/2024 for examination of PW's lordship. The informant also is from Bengal lordship, West Bengal lordship. There are 11 translated witness lordship. Custody trial may not be necessary at this stage lordship. He will regularly appear any condition lordship. He is not from outside lordship, he is a local person.
Yes, PP.
The accused, my lord, being the security guard, my lord. It is offense, my lord.
It is true,
It was intentional, my lord.
but he is not
Let the
circulate the
victim-
outside video
Right,
lordship.
motion, let the victim guard examine, my lord.
When is it fixed?
19/5 lordship. On last lordship 22/3/4 lordship, PW was fixed, but on the PW was absent. Now next day is fixed on 19/5 lordship. It will take some time lordship. I may be allowed to to go on in bail lordship with any condition lordship. There is a 11 witness lordship. There and charge sheet was filed on 30/10/2025. Till that no PW was examined lordship. The long incarceration lordship.
It says informant, my lord, victim guard may be examined, my lord.
Informant also from West Bengal lordship. And
Where is the victim girl from?
victim girls also from lordship.
No, it's from Assam.
This is from Assam, my lord, Assam.
He is from Assam. 1910 lordship. This is a long lordship. Already 179 days lordship. Finally consider
The
lordship.
victim, my lord, the informant, my lord, she belongs to, my lord, West Bengal. Otherwise, my lord, she is employed in, my lord.
Working there.
Yes, my lord, Sai.
Whether now he is
Totally
working or
yes,
not
my
lordship, he may be transferred lordship. But his
Victim
address
guard is,
is
victim guard is from
We are
working.
interested in the victim girl. Informant may come later also.
lordship. 19/5 days long is kindly consider lordship, only 179 days lordship. He will appear lordship.
Your mischief is such that
And section
we have no sympathy for you.
and section 14 also not applicable lordship. Those are spam lordship, but as per section 14 lordship, here in the section 14 says lordship, 15, sorry, 15. Section 50, any person who store or possess pornography material in any form of invoice, file or but fail to delete. But in as per statement of victim lordship, the video was found from deleted file. They stored the he deleted the file video lordship. Neither he circulate nor he uploaded in social media.
Charge has been framed under what section?
Under same section, lordship. Section 77 and 230C and redo section 14 and 15. But there, what
And deleting is in case you receive from somebody After that, in this case, you are yourself, you have made the video.
But because he was under as per instruction, he was intoxication due to some institution lordship.
That is an excuse.
Then I'm not on merit lordship. This I'm for 179 days lordship.
That is what we said. We have no sympathy for you because of the kind of act you have indulged in.
Charge sheet also, charge sheet submit 30/10 lordship 2025. Till date not, PW was examined lordship. The long incarceration lordship. Only one data spec also lordship.
Let the matter come up after 19th of May, my lord, to see whether the victim examined or not.
Yes, all right. Let us fix it after 19 then. Our learned counsel for the petitioner, learned petitioner PP. Status report as called for has been received and it appears that charges have already been framed. And the matter is fixed for evidence on 19/5/26.
I'll be fixed on 20 or 21 lordship.
Learned
21.
petitioner PP submits that the prayer for bail may be considered after the victim has been examined. Hence, list the matter again on
21 lordship. If I will produce the certificate copy of
21st of May.
much of lordship.
I'm being at him. 15.
Okay.
My lord, here, my lord, one miscase has been filed because the victim has to be made a party. There is a dispute is that the wife, that is why the IA criminal 262 of 2020. So he is allowed to make party, we file, send a notice to.
Yeah.
IA criminal 262. This is
262 is for suspension of sentence.
Oh, no, my lord, then another, I am sorry, my lord, another, this is 39, new miscase. 24 of it. It no, 262 don't know. 394, yes, my lord, sorry. My lord.
Had learned IA 394. Had learned counsel for the petitioner, this IA has been referred seeking implement of the victim as respondent number 3, whose particulars are as follows. Let's see in paragraph 3, bold part, page 4. Prayer is allowed. Proceed. Victim is hereby implemented as respondent number 3 in the connected criminal petition number 791 of 21. Necessary application for correction of the cost title made. List again of highest tense disposed of.
My lord, may I have another prayer, my lords, and charge sheet and one additional section was added, that is 376 IPC, my lord. But here, this is not in, so can I take a leave by amended cost title incorporating that an additional section? Or
That mother has to file IA. Separate IA. Separate IA will be required.
Separate IA you have to file.
if lordship is permit, then we'll amended cost title, I will
Or
supply
they can
this.
file additional affidavit, I think.
All right, additional.
Yeah, it is not very helpful.
Okay, all right. Obliged, my lord, and I will.
Eight five.
8-5.
Item number 21.
Service completed, the amicus may be appointed.
Otherwise, lordship, TCR is there, lordship.
I'll learn it counsel for the petitioner. Learn it. Additional PP. Notice on respondent number 2 is complete, however, none appears to represent the respondent number 2. Hence, so and so is appointed as amicus to represent the respondent number 2. So present as in here.
And the steeper actually.
Already. Extra copy be served upon her.
Let the matter be listed, lordship.
Should again on. Just give it.
Date, lordship.
Even May.
Obliged.
Item number 22.
May it please your lordship, for item number 22 and 23, kindly pass over to matter for the time being.
Time being.
No, for the time being,
23.
22 and 23.
Already.
Always.
24.
May it please your lordship. Although it's a regular bail, my lord, I have been granted interim, my lord. That is, my lord, 18/3/26, my lord.
Yes.
Your lordship may have a look, my lord, 18/3/2026, the order passed by this.
CD is there.
My lord, charge sheet has been,
Charge
my
sheet,
lord,
charge
I will face the trial, my lord.
But only, my lord, the query, my lord, his on the last occasion, the submission was that, my lord. The charge sheet was submitted on, my lord, 15/3/2026. Whether, my lord, the submission was that, my lord, it was not received in the court, my lord. On time, my lord. But I have gone to the TCR, my lord, the charge sheet received on time, my lord.
No, charge sheet was, my lord, it was seen on, my lord, 18/3/26, my lord. I have just checked out, my lord.
Arrested on
18th, arrested on 5/3/26.
5/3/26, then 18/3, my lord.
That was not the ground on which interim bail was
No,
granted.
no, that was not a
No,
ground.
no, that was not a ground, my lord. He was granted interim, my lord.
On merits.
On merit. And if your lordship, my lord, the forwarding, if your lordship sees, my lord, page 17 for a once, my lord. 17, my lord. And there, 17, my lord, lordship will see, my lord, that box, my lord, Faridul Islam, 28 years old, my lord. He is the petitioner, my lord. But if your lordship goes to the brief facts of the case, my lord, it is about one Asghar Ali, my lord. The main accused, my lord, who have been already arrested and got bail from this court, my lord.
Since interim was granted on merits, so we have to consider on merits only.
Then, my lord, let him cooperate, my lord.
Yes, sir, definitely I will go.
This is the charge sheet case, my lord.
What is there to cooperate now?
To cooperate with the trial, my
The
lord.
trial. All that, Dr. Learned Counsel for the petitioner learned additional PP, PCR as called for has been received. The petitioner, this is an application on under the order dated 18/3/2026. Okay, there are two. This is a charge sheeted matter and the petitioner by order dated 18/3/2026 was paid interim bail. Considering the fact that the petitioner was arrested from the vicinity of his own residence and there was no allegation of any recovery of any contraband from the petitioner. On having regard to the nature of the allegations as against the present petitioner and the fact that the charge sheet has already been submitted, the order of interim pre-arrest bail is hereby made absolute on the same terms and conditions as contained in the order of interim bail dated 18/3/2026. Petition stands disposed of accordingly.
I am obliged, my lord.
25.
May I please refer your lordship? Lordship, kindly fix the date next week since fresh IA has been filed today. There was a mistake in the cost title. Any date in the next week, lordship.
Order is placed for by learned counsel for the petitioner lays the matter again on. Just give it. 8/5.
Great.
Item number 26.
May I please, your lordship? If I have taken the step, lordship, to the respondent number 2, lordship. It is the proximate.
Service report is awaited, madam.
You have not taken steps.
I have taken the step.
When?
lordship.
Till 22 you have not. Today is 24th. As per office note dated 22/04/26, steps for issuance of notice has not been received by the registry till that date. Petitioner to take steps accordingly. List again on. Legal May.
Obliged.
Item number 27.
In this case, I'm on interim lordship from 25/3 lordship, there's an order. And it should be, in the meantime, there is a development lordship, the new application has been filed by the respondent number 2 and the respondent number 3. In fact, lordship, that before the trial court also it is there, and we have annexed it in along with our petition lordship as annexus 6. Out of misunderstanding, the whole thing happened, lordship. So they filed an application before the trial court, and that we have filed along with our application also as annexus 6. Then on the merit, lordship, after going through it, the court has passed the order. And now, lordship, and made absolute lordship in view of the fact that lordship, both the informant and the father of the victim has filed the lordship, that it is out of a misunderstanding, lordship, all things happen, lordship. And the interim order was passed on merit, lordship, that is on 25/3/2026. After hearing both the parties and the lordship, my learned PP has also used. And now Lordship can make it absolute Lordship if necessary. Lordship will appear before the trial court. Lordship can give any. Before the IO, I will go and whatever condition Lordship will give.
This was some issue about bail bond
Yes.
not being accepted.
It is the second order, Lordship. That's Lordship. First order is of 25-3.
Yes.
Yeah, 25-3. This court passed an order, interim order. Then the Lordship, for some reason or another, the bill was not granted and all that. So this court passed the second order, fixing the date to date. But in the meantime, Lordship, after that order, Lordship, the 27-3 order, he was given bail. So that is complied with. Lordship, High Court order is complied now. Initial
No, pursuant to the last order dated 27/3/26.
Yes.
Has the bail bond been accepted? No.
Yes.
Yes. So we are, that part is now over.
That part is over.
Interim part is over. What was the allegation otherwise?
Section 8 of the POC.
Page 28. Page 28.
Page 28 is the lawsuit. So you can see FIR is at page 28. Yes, particular is at page 28, Lordship. The Lordship allowed me সম্মানপূর্বক বিনতে নিবেদন এই যে ইমান তারিখে দিনৰ ইমান বজাত it is page 28, Lordship.
Yes.
সম্মানপূৰ্বক বিনীত নিবেদন এই যে ইংৰাজী ইমান তাৰিখে দিনৰ পৰা ইমান বজাত মোৰ ভতিজা ছোৱালী তঞ্চু বয়স ইমান ঘৰৰ ওচৰতে থকা দোকানৰ পৰা ঠাণ্ডা বটল আনিবলৈ যাওঁতে ওপৰত উল্লেখ কৰা আসামীজনে মোৰ ভতিজা ছোৱালীক হাতত ধৰি টানি দোকানৰ ভিতৰলৈ লৈ যায় ভতিজা ছোৱালী অসৎ উদ্দেশ্যেৰে বুকুত গাল স্পৰ্শ কৰে আৰু গালত চুমা খায় এতিয়া ভতিজা ছোৱালী ভয় খাই আসামীজনৰ হাতত কামুৰি আসামীৰ কবলৰ পৰা ওলাই আহিবলৈ সক্ষম হয় উক্ত ঘটনাৰ বিষয়ে ভতিজা ছোৱালীজনে আহি মোক চিনি বিপৰীত then Lordship, that all these as Lordship, in the trial court also the victim mother and the informant, the father and the informant, both of them has filed the affidavit, Lordship, that it is some out of misunderstanding it was done.
Page 42.
Page 42, Lordship. So after that, Lordship, this court consider all that and the pass the order, Lordship. Now, Lordship, before this court also they have appeared and both of them has filed affidavit, Lord. Page 42.
Yes, PP.
As that case, my lord, scan copy may be called for, my lord. Otherwise, my lord, the petitioner is already on interim, my lord.
Then what to do with the scan copy now?
I let you, whatever condition, Lordship, no point, Lordship. Corporate Lordship, it is not that Lordship to do all this.
Fix a date, appear before the trial court.
And this court fixed it, any date Lordship, I'll go and.
File appearance bond.
No point.
Good heard, Mr. Learned Counsel for the petitioner and learned additional PP. This is an application on the so and so. The allegation against the present petitioner is that on the day of occurrence, when the victim, aged about 13 years, had gone to the shop of the accused petitioner to purchase cold drinks. The petitioner took her inside his shop and committed sexual assault upon her. Full stop. The petitioner was arrested on 3/3/26. Subsequently, in the instant case, by order dated 25/3/26, the petitioner was granted interim bail and was subsequently released from custody. Para. It appears that the informant side had lodged a petition before the learned court below, stating that the FIR had been lodged on misunderstanding, and the informant side had no objection if the petitioner is granted bail. Full stop. Para. Having regard to the above, the order of interim bail dated 25/3/26 is hereby made absolute. You are appearing for respondent. Also heard so and so for respondent number 2 and 3. At the top and the top. The bail has been granted on the condition that the petitioner shall regularly participate in the trial if one commences, and shall not try to influence the witnesses in any manner. Petition stands disposed of accordingly.
I'm good.
Finding it in 22.
Yeah, please, Your Worship. PCR was called for it, Your Worship, in this manner.
Yes.
Your Lordship, after charge sheet was being filed, the PCR was being called for, and the sections involved herein are 196(1)(a), which is commission of offence in the worship.
How many days?
Lordship, he is behind the bar for 66 days as of today, Your Worship.
66.
66 days. And the
Then statutory period is over.
this charge sheet.
Oh, charge sheet.
Charge sheet has been filed, and therefore the PCR was being called for. And Your Lordship, the punishment.
What is the allegation?
The allegation here 196(1)(a) is the commission of offence under the worship place. Your Lordship, is 5 years of punishment. 299 is the malicious act intent to outrage the religious feeling. That is 3 years of punishment, Your Lordship. 3(5) is a common intention, and Section 13 is involved one of Assam Cattle Preservation Act, that is slaughter of cows, is 3 years of this. And the
What is your name?
my name is involved in the FIR, Lordship, and the things has been recovered from a house.
Tajuddin and
Taizuddin and Lordship Roisuddin.
Roisuddin.
Yes.
For the other two, I think one bail was granted to one co-accused some days back. Hafizur or somebody.
This case only, there are only 2 accused persons, by the way.
2. Is this the first bail application?
Yes, Lordship.
Yes,
122 kilos of beef recovered, my lord, from their possession, my lord. And they were caught red-handed, my lord.
My humble submission, your lordship, since the things has been already recovered already, your lordship, they may be allowed to place a trial, your lordship. So your custodial detention is not be warranted, your lordship, in this case.
had learned counsel for the petitioner and additional PP. This is an application on the so and so. The brief of the case is that on 15/2/26, upon receipt of prior information, the police raided the house campus of accused petitioner Tajuddin and recovered 122 kgs of suspected raw beef meat along with dao and knife, DAO dao. And the other co-accused Roisuddin was also present there, and both of them were caught red-handed. And they failed to produce any valid documents for possession, transportation or sale of beef. And, learned additional quickly submits that the involvement of the petitioner is clear from the material available in the CD, and accordingly charge sheet has also been submitted in the case. Para. On the other hand, learned counsel for the petitioner submits that the petitioners have spent 66 days in custody and their further detention may not be necessary. Having regard to the fact of completion of investigation and the period of detention of 66 days, the further detention of the petitioners is not considered necessary. Accordingly, the prayer for bail is allowed. So and so petitioners shall be 50,000. Surety each of like amount.
Recorded, man.
We have already recorded.
Much of this.
23. Time being 23.
Yes, sir.
Latif, FIR is at page 13, Latif. So before my learned friend start, my lord, now we have received the case diary, my lord. And I have gone through the case diary, my lord, today is 94 days, my lord. And investigation could not be completed because, my lord, the medical report and FSL report is not yet received, my lord. Otherwise, my lord, the condition of the guard is very serious, my lord. But I think we are entitled to bail, Latif.
94 days today.
94 days.
So what option is there?
My lord.
Yes. That is why default bail.
Yes, sir.
Had
And that apart, we are this main, we are not the main accused, Lordship, the perpetrator.
heard Mr. D. learned counsel for the petitioner and Mr. Uro learned additional PP also heard learned amicus representing the respondent number 2.
I am for the respondent number two, Lordship. I am for the information.
Earlier amicus was appointed, after that you appeared. He gave his name, appearing for respondent number 2. Your name, you give.
D. Chaudhary.
It is stated that the petitioner has crossed the statutory period of detention before the charge sheet has been filed, having spent 94 days behind bars, and the investigation is still pending. Full stop, their para. In view of the above, the petitioner. One petitioner.
Two petitions.
How many? Two.
Two petitioners.
Petitioners so and so are entitled to default bail. Accordingly, it is directed that the petitioners so and so shall be released on bail of rupees 50,000 with one surety each of like amount to the satisfaction of the POCSO court.
Nagaland.
Special Judge POCSO Nagaon. Petition stands disposed of accordingly.
Yep.
29.
My lord, due to inadvertence, my lord, service could not be taken up in this method. Also case, my lord. I have a prayer, my lord. Instead of speed post, may I be permitted to serve notice to the public prosecutor, my lord? Item number 29.
You have not taken steps there.
It was inadvertently, my lord, it was left out. If I may be allowed to take service through the public prosecutor, my lord. Take the registry, my lord, registry, then the registry will forward it to
Yes,
us.
sir. In place of speed post, my lord. That's my limited prayer.
For it. Had learned counsel for the petitioner and learned additional PP. TCR has been received. Scanned copy of TCR has been received. It appears that petitioner has not taken steps as directed earlier. First, the prayer has been made to take steps through the registry and office of the public prosecutor. Once the prayer is allowed, list the matter again on.
Obliged, deeply obliged.
Item number 30.
Made, please, your Lordship. Lordship, this is a regular bail, Lordship. POCSO is there, Lordship, 86 days today in jail custody, Lordship. And we have taken step on, Lordship.
May I please, your Lordship? Lordship, in this matter, we will be filing an objection, Lordship. May grant us further time to do so.
My lord, this is a regular bill application, my lord. He was a driver, my lord. And he was behind the bar 54 days, my lord. Only lordship 4 days remain, my lord. Mandatory period is 60 days, my lord.
Lordship, the value is very high of the contraband.
As per was actually 135, lordship, custom act, my lord. Mandatory period is.
Where is the affair?
FIR, lordship, kindly see at page 11, my lord. Some button lot was seized. He was a driver, my lord. Lordship, may I read, lordship?
11 is Panchnama.
Panchanama, lordship, customs, there. FIR means.
Lordship,
Panchanama.
CD is also not available today. It will be difficult, Lordship.
He was arrested in the month of March, my lord, 2nd March. 54 days, my lord. As per section 135, my lord, Customs Act, my lord, may not less, minimum lordship punishment is 1 year, my lord, and maximum is 7 years. ইমান দিন কি কৰিলা?
How many days? 54.
Fifty-four days, my lord. When consider the period of detention, my lord, kindly allow lordship. You will appear, my lord, each and every night, my lord.
Be fixed,
Over
Lordship.
the land court below, my lord.
CD will be necessary.
And he was fast, you filed before the landed court below, landed court below was rejected only without any ground, my lord. Lordship, kindly see page 18, my lord. The observation was given, page 20, my lord. Upon considering the submission advanced by the learned counsel for both sides, objection raised by the custom department, materials available to the gravity of the substance allegations, substance value of the seized articles, seized stage investigation, court is of the considered view that it is not a fit case for grant of bail of the accused at this stage. So lordship, now lordship is behind about 54 days, my lord. You will appear, my lord, at each and every date, my lord. Consider period of long detention, my lord. And he was a driver, my lord. He is not the owner, my lord.
So today is 54 days. By the time you file objection, statutory period will be over.
We were supposed to file long ago, but their contact information was not given. Hence, we were not able to file the objection. Lordship may fix a short date. We'll file it today itself.
My lord, he will appear, my lord, at this
We'll
stage.
file it
Each and
today,
every
Lordship.
date, my lord. He's a driver, my lord.
Short date may be
Consider we have
fixed.
detention.
Monday, Lordship.
All right, Monday. Or learned counsel for the petitioner. Learned counsel for customs. Takes a short date to file objection. Hence, list the matter again on Monday.
Always.
32.
May I please, your lordship? So this bail petition was earlier rejected by your lordship, lordship. Here this trial is there going on, lordship, and 3 independent witnesses has been examined, Caesar witnesses. They have not supported the prosecution case. Now, out of the 6 witness, lordship, only informant remains, lordship. Other are the expert, FSL expert and the IO, lordship. So lordship, when rejected the earlier application, lordship says that police witness will also be able to prove the case. Only informant remains, lordship. And informant already 3 dates after thereafter, lordship has notice has been summons has been issued, and she has not appeared. Turn up, lordship.
And 32.
32.
My lord, I have paid the skin copy, my lord. The evidence of witnesses are not available, my lord. Perhaps it was not forwarded, my lord. The commercial quantity, my lord.
Do you have certificate copies?
I have annexed it. Annexure starts from annexure 9. lordship.
Huh?
Starts from annexure 7. lordship. Page 21. lordship. On earlier occasion also, lordship has perused this in the with it's 21. lordship. 21 and 23 and 3 witnesses. In the charge sheet, there are 6 witness, lordship. One is the informant, who is the police officer, lordship, and 3 independent witness and the expert and the IO, lordship. So 3 independent witness, they did not support the seizure.
That was the case earlier also.
Yes.
Independent, in your earlier bail application
Yes.
also, this was there.
But Lordship, actually, last time I have not gone through the charge sheet, Lordship. So I thought that there were some more police witnesses, Lordship. Only I informing this left, Lordship.
Only in cross part, my lord, he has said. Otherwise, in SIP, my lord, all the my lord, independent witnesses, they have implicated, my lord. Police called him, my lord, and my lord, he saw. I went to the house of the accused Abed Ali and told me that they recovered ganja, and I saw 7 numbers of polythene packet and fully obtained my signature on paper. Exhibit one is the said paper, and exhibit P3 is my signature. Man.
But
He has proved his signature in the seizure this month.
But in the cross, Lordship, I do not know where from police recovered.
That is in the cross, my lord. That is the trial court will consider, my lord, at the time of final argument.
So if they do not know, Lordship, from whom those were recovered, then how we have supported the seizure, Lordship? As on day, Lordship, 260 days in custody.
Where is the charge sheet is available?
No, Lordship, I have not annexed it. I think in the scan copy there. Charge sheet doesn't. So.
Yes. There are six
Six.
witnesses mentioned. Out of that, 2, 3, and 4 are examined.
And one is
One is the WSI, one public honeycomb. And
the
number
FSL
5 is
expert and
FSL and number 6
IO.
is IO. So public, one remains.
One remains, Lordship, only informant remains.
Question is that, my lord, at this stage, my lord, whether.
What is the PW1
She has
as
been
per the
someone,
charge sheet?
she is the informant, Lordship.
She can also prove if she was present at the time of the seizure.
She lost the FIR, Lordship.
Yes, possibly.
Because of 37 would still come. my lord.
So how has the situation changed from the last order?
Lordship has observed that
Yes, that way that police witnesses will be able to prove. There is one police witness remaining.
only the informant, Lordship. She has
Yes,
to be.
she was present.
She has to be supported by some witness, Lordship, because she is making the seizure, Lordship.
She was present during the recovery, I think. That is why she filed an FIR. Is it not?
As per the FIR page number 30.
So nothing has changed from the last order we have passed. There also we had said that the police witness will be able to prove.
He has been summoned on 4 occasions, Lordship. Now, he has not turned up.
At this stage, we cannot say that there is ground to believe that you are not involved because witnesses remain. Her statement must have been, she was the informant.
She was the informant, Lordship. So 161 will not be there.
No, I would have recorded his statement. On the basis of the statement, it is possible that they can still prove the case. All right, let's see. We'll pass on this.
Is there in 35?
I have this.
Right. My lord, in terms of the, my lord, interim order, they appeared before the IO, my lord, on 10/3/2026, 11/3/2026, and 12/3/2026.
3 times.
3 times.
Statement is recorded or not?
A statement has been recorded.
Recorded, but this is a POXO case, Lordship. And firstly, they have not implicated, Lordship. Then they are directed to implicate the informant, Lordship. They have implicated them, and service has not been completed yet, Lordship.
No, who has been directed to implicate?
We are directed. Accordingly, it was implicated.
Implicate. Oh, I thought implicate. Service is not complete. Correct. Service on respondent number 2, not yet complete. Have you taken steps?
Yes.
The step has been taken.
OP has been served to the, my lord, learned friend, my lord,
All right.
First, we have.
in terms of the High Court's order.
Have its service list again on so and so interim order passed earlier to continue till the next date of lifting.
Obliged.
Lordship, CD, may we update or Lordship, we have to retain.
If it is sufficient, then
Okay.
CDB retained.
Date may be fixed.
Of course.
12th May.
12th May. Obliged.
36.
Every day, Lordship. Lordship, the respondent number 2 informed me over phone that he met an accident while coming to court. A place for some time. The matter may be fixed any other day, Your Lordship. As per last order,
Respondent number 2 contacts the petitioners, not the court's Lordship by other means. The POCSO matter, Lordship.
Yes. Nothing surprising. This is a place where accused and victim come on the same vehicle to the court on the day of deposition.
Lordship, as per last order 26(3), he has to file additional affidavit, Your Lordship.
Will attend the city, Lordship.
Heard learned counsel for the petitioner, none appears for respondent number 2. It is informed that learned counsel has met with an accident. Who met with an accident?
Respondent number 2.
Is informed that the respondent number 2 has met with an accident today. Hence, list the matter again on.
Even me.
After a week, Your Lordship.
39.
Obliged, Your Lordship.
39 to 1
Lordship, 39 CD may be received. The matter may be passed over for the time being, Your Lordship. Senior counsel M.S. Lordship relax in other court, Your Lordship. After some time. Your Lordship.
Right.
Publish.
41.
41 to city. City was called for, my lord. May I pray one thing, my lord? Yes, Lordship, page 13, my lord. In same FIR, my lord, earlier 2 persons have filed an AB before this honorable court, my lord. Earlier interim was granted and later on one of the accused was absolute and 2 were rejected, my lord. So may I pray, my lord, similar benefit may be given to the petitioner, my lord, if something is found in the CD, my lord, my bail may be rejected, my lord. Some opportunity for recording of this statement of the my lord petitioner, my lord.
What is the FIR? Page 8.
Page 11, my lord, this is vernacular, my lord. I'm reading, my lord, page 11, my lord. It is a cow slaughtering, my lord, in my house, my lord. It is a 3 years offense, my lord. সন্মান সহকাৰে জনাও যে আজি ইংৰাজী ইমান তাৰিখে গোপন সূত্ৰে জানিব পৰা মতে নিজ বাগমাৰী গাঁৱৰ মহম্মদ আমিৰ হুছেইন নামৰ লোকজনৰ ঘৰত বহুত দিনৰ পৰা অবৈধভাৱে গৰু কাটি মাংস বিক্ৰী কৰি আহিছে। উক্ত সংক্ৰান্তত মই মাননীয় জিঞ্জিয়া থানাৰ ভাৰপ্ৰাপ্ত আৰক্ষী বিষয়া মহোদয়ৰ নিৰ্দেশ মৰ্মে ষ্টাফ সহ নিজ বাগমাৰী চুটপাম গাঁৱৰ মহম্মদ আমিৰ হুছেইনৰ ঘৰত তালাচী কৰা 4টা গৰুৰ ঠেং, এটা গৰুৰ মূৰ আৰু এখন বঠি দা পাওঁ। স্থানীয় সাক্ষীৰ সাক্ষাতত জব্দনামা অনুসৰি জব্দ কৰা হয়। যদিও পুলিচ অহাৰ তথ্য জানিব পাৰি পদকীয়াজন পলাই যায়। প্ৰকাশ থাকে যে উক্ত পদকীয়াজনে অন্য সহযোগীৰ সহায়ত আজি গৰু মাংস কাটি
CD not available.
Lordship, let the CD come, Lordship, because
Yes. Up to date CD is not available. List again on.
Can it be, my lord, 16th, my lord? 16. Funny, my lord. 14, I'll be out of station, my lord.
All right, 16.
16. 11, my lord, then?
On 11.
Obliged.
42.
Received.
May I please, your lordship? Kindly pass over the matter for the day as my senior is not.
For the day.
Yes.
Wait, on prayer of counsel for the petition and list the matter again on
Next week,
28. CD receipt be retained.
obliged.
All right, and 44.
Well, please, your lordship. So this matter pertains to first a criminal appeal along with a interlocutory application. Now, what has happened is that this matter has been pending since 2022, and now 4 years have already passed. Always due to some sort of like paucity of time or due to some inconvenience, this matter gets delayed. Like the last time the interlocutory application came up before this honorable court on 17/7/2025, almost like on last year. And in that particular day, the honorable court had issued a direction to take up the IA along with the appeal, because this IA has been filed by the petitioner since he has been served with a conviction of 10 years of sentence. Now he has already undergone 3 years, 6 months of his sentence. So almost like 1/3 of the sentence, as there is a proviso in 479 BNS, that is for the under trial, but still it can also come for the persons who wants to reduce, like they have filed an regarding suspension of sentence. So basically in this particular matter.
So the IA is still pending?
Yes, yes. I is still there.
10 years punishment.
Yes, 10 years punishment.
So we may file a objection also.
Already filed. Yes, yes, yes. They have already filed an objection. Objection was filed.
What is the conviction on section?
4, section 4. Objection was filed on 12/12/2023 from the prosecution. So my lord, here basically going into the merit of the case, it will come in during the appeal, but for the IA, we are basically seeking, since he has already served the required amount of sentence, like 3 years, 6 months is already inside jail. And our main grounds in this particular case was that there was some inconsistency in the testimony of the witnesses, along with the medical, they would like the medical report also, which shows that regarding the occurrence of the offense. So directly pointing and going to the merit of the case, we can go with the appeal. But in the meantime, regarding the interlocutory application, we are praying that he may be released since he has already served 3 years, 6 months. And moreover, the fact remains is that during his stay in the jail, he was also being diagnosed with a number of medical ailments, which had already been taken care of. Like already report was also there, since he was having some.
We'll dispose of the IA.
Yes.
Either way.
It is lordship 164 statement. I have the lordship CA as implicated. And rest lordship that the victim lordship that I am going to lordship.
Trial is over. You are on 164 now. Because
That
they've
is for
implicated in
prohibition
the
lordship.
deposition.
Whether she is constant in her depositions, that is a 164 and as well as the evidences part lordship. That is I am going to read that lordship.
Basically, my lord, in this particular matter, we have also filed an additional affidavit also. This affidavit was filed, why? Because there was one particular case in which the informant was implicated. Now, what has happened is that basically this whole, why this case was filed from the informant, like the victim side was, we have a complete doubt that it was filed due to the fact that there was some dispute between the informant in the case where this particular victim's father, who is the informant, and in another case, he got implicated. And now he is also serving conviction in that particular case. That is why we have filed an additional affidavit to showcase that there was a dispute, civil dispute actually, regarding some sort of monetary dispute, which finally took the turn and culminated in the lodging of the FIR from the victim's side against the accused petitioner, this appellant. Now, what has happened is that the appellant was a contractor. He had he had supplied some art materials during that point of time. Now, there was some sort of amount which was to be paid from the informant side. Now, he was not able to pay. Then later on, what happened when the informant called the accused appellant to his house, then at that point of time, they have lost this FIR. But actually, in the additional affidavit where this particular informant he is being implicated, there we can directly see that actually on that day he was being, this particular accused appellant, when he went to the house of the informant, he was mishandled, and in fact he was assaulted from the informant side, from the like victim's father's side. But later on they had lodged an FIR saying that as the accused appellant had misbehaved and had committed that crime against the victim daughter of the informant. So there, and also the fact was that there was one eyewitness who was not at all examined, who was present at that place of occurrence during the time in 164. The victim had stated that there was one more person, but in 161 that person's name was not there. So there was some inconsistency was also there. So considering those facts, and at the same time that entire case has been decided on 164, that is presumption. And since this particular accused appellant was not able to adduce his defense on that at the time of trial, maybe this has resulted in his conviction. But as we go through the testimonies, there are inconsistencies, and that has to be taken with the appeal, my lord. So in the IA, we are mainly now praying that at least he could be released on bail, since he has already served 3 years, 6 months from the date of his conviction. That was on 28/9/2022, passed in the in this particular session special case. So our limited prayer in the IA is that since there are some sort of inconsistencies in the testimonies of the witnesses, along with the medical health of the accused appellant, since he was being treated with medical assistance during his stay from the time of his conviction, and at the same time that since already he has served that minimum period of sentence, which is under the proviso of 479 BNS, my lord. So if that can be taken into account, and at least he could be released on bond on bail on conditions, my lord. In the meantime, appeal can be taken up, my lord. We will go for the final hearing, my lord, if required. Since objection is already filed.
Here, first of all, Lordship, in 164, Lordship, she has not disclosed that there was some another person was there. She has stated, Lordship, she was all alone also. And after going to the statement of victim statement, Lordship, that is the position PW2, going to Lordship, she is constrained, Lordship. There is her testimony cannot be left as
64, she mentioned 4 occasions.
Lordship, 4 days.
Four days, that means every time she goes on a bicycle, he takes her away on 4 occasions.
But Lordship, she is minor. Will not do.
No, we are not on minority or majority. We are on believability. That is any medical evidence, 13-year-old girl.
My lord, medical evidence is there.
Doctor not examined.
Examine, my lord. Annexure D of the appeal, my lord. In the
PW?
PW 3, Prosumita Das. And we have annexed the report also, annexure D, page number 32.
PW3 is one Ranjit Das.
Junita, actually it is Sumita Das.
Dr. Junita Das, that will PW7 also. PW7.
7.
Apology, my lordship. PW7. PW7.
PW7. PW7 is.
The report is on criminal appeal.
Yes.
Annexure D, my lord, page number 32.
No injury on private parts.
Yes, madam.
This Lordship,
No external mark
on
of injury
11
seen at the time of examination. No visible mark on her private.
Date of occurrence. Last 2 years. From date of filing of FIR.
Yes, madam. 10/2/2022, the FIR was registered.
If this has been going on for 2 years, how come section 4 was invoked? Section 6 would have been there.
Yes. Section 4 says.
Charge itself appears to be defective. He says it's going on for 2 years.
Yes.
Claim charge under section 4. Yes,
No,
yes.
no, yes. We have 43. Or 40.
Mayor, please, my lord. As per last order, my lord, service report was still awaited. Steps were taken through the concerned PS of Bhangagar and Digboy. I have checked with the office note, my lord. Through the Digboy PS, no such person has been found. And through Bhangagar PS, the service report is awaited. Steps were again taken. Through police station, my lord.
কেতিয়া লৈছিলে?
Last.
22-4. 22-4.
Recently,
Press notice, huh?
yeah, day before yesterday, yes.
It appears that first steps were taken only on 22-4-26. Hence, await service list again on so and so. Interim order passed earlier to continue till next date of listing.
Obliged, my lord.
13B. 46.
May I please, your lordship, here, lordship, the service report on the respondent number 2 is complete, lordship. So I need to take fresh step, I think, lordship, because it's long back the steps was taken.
Notice on respondent number 2 not yet complete.
Lordship, it
Petitioner
should
to
be-
take
Let it be go through the local police station, lordship.
fresh steps to local police station. Routed through the registry. List again on
14-5.
I am obliged.
39. And
it is received.
Monday or Tuesday, Rosimi, please.
Hmm?
Monday or Tuesday, Rosimi, please.
None appears on call for the second time. CD is received. List the matter again on Monday, did you?
5B.
5 May.